Hi, this is Mark Richards. I am co-chair of the Post-Grant Patent Practice Group at Brink Skilson Lyon. I'd like to welcome everybody to our webinar today. There are three of us at the firm who will be presenting today, three different segments talking about different subject matters areas involving post-grant patent practice. I will be talking about recent statistics at the PTAB and recent decisions. Jim Cleland will next be talking about PTAB decisions involving multiple IPR petitions. And last, Nick Ristori will be talking about appeals of PTAB trials to the Federal Circuit. So looking at some recent statistics from the Federal Circuit, Patent Trial Appeal Board, you can see in the last year there's been a significant increase in petitions for IPRs, CBMs, and other proceedings. Although I think it's fair to say that in the past year, the number of filings seem to have reached somewhat of a steady state at about 150 petitions filed per month on average. So I think we've seen sort of a maturing of the petitions being filed, and we're achieved somewhat of a steady state filing now at the PTAB with the EIA proceeding. So the types of petitions that are being filed are directed to primarily electrical computer technology patents. Let's say almost 2/3 are from art units that examine electrical computer inventions, whereas 1/4 of the filings deal with mechanical and business methods. Based on my general review of filings at the PTAB, it seems most of the proceedings do involve more inventions directed to business methods. So with that, I think it's fair to say that a vast majority, 80 to 90% of the technology being reviewed by the PTAB are patents related to computer and software and business method related inventions. There's quite a significant minority, now up to almost 8% of the filings dealing with in the pharmaceutical sector. Now, interestingly, as many of you know, after a petition is filed, the patent owner has an option to file a preliminary response. Those responses are optional, and we're seeing up to 20% of the patent owners are not filing a response in view of the petition. I believe there's a number of reasons for that. A number of the IPR proceedings are settled early on before the patent owner files their response. Also, in some cases where the grounds for unpatentability alleged in the petition are quite strong, and perhaps the patent owner does not feel that the cost of challenging the petition are worth the expense. And lastly, in some cases, there's a debate whether or not, when there's ongoing litigation in the district courts running in parallel, whether the patent owner might tip their hands as to their litigation strategy in filing a response. So looking at in more detail about how the petitions for the EIA trials are being handled, it's interesting to note that the percentage of petitions that are granted and trials being instituted has increased significantly from the first year, where it was up to 90% were granted, whereas the last 2 years where it's dropped from 75% and lower of the number of petitions being granted and trials being instituted. Now, also looking at the number of IPRs that were filed in fiscal year 2015, it's interesting that We're on track for more than 700 trials to be instituted in this fiscal year. As you can see from the latest trends in the number of petitions being granted, on the bottom, the red bars show that more and more petitions are being denied over time. This slide shows some statistics regarding final decisions and how the cases are being disposed of. And I think it's interesting to note that the number of cases being settled so far exceeds the number of final written decisions that are coming out of the PTAB. And of those final decisions that are being made, this slide shows some interesting statistics. There's the bar coded in yellow shows decisions where the claims were found to be not unpatentable. In other words, those claims were upheld. And there seems to be quite a number of cases where at least some claims have been upheld as being patentable. As the next slide shows, however, if you analyze the cases on a claim-by-claim basis, you'll see on the bottom bar that small sliver in green shows actually the number of claims out of all the claims that have been challenged in the IPRs that have been found and upheld as patentable. And that comprises only less than 10% of all claims that have been challenged have been ultimately found to be patentable, which is a very small number. So it's quite a significant, 90% or so of all the claims being challenged have been found unpatentable by the PTAB to date. So with that, I'd like to talk a little bit about some recent decisions that have come out of the PTAB. So this first case, a recent decision involving Space Exploration Technologies Corp., which is also known as SpaceX, versus a patent owned by Blue Origin. I think it's interesting, the parties who are behind these companies bring this case to quite a level of media attention. Behind SpaceX Corporation is entrepreneur Elon Musk, who's a co-founder of PayPal and founder of Tesla Motors. And behind Blue Origin is Jeff Bezos, founder of Amazon. So what's interesting here is that SpaceX won the contract with NASA to launch rockets from Cape Kennedy, but Blue Origin got the patent on a process and systems for capturing and recovering rocket boosters by landing them on a floating platform at sea. So I think because of the competition between the two parties, SpaceX challenged this patent in a PTAB proceeding. And as you can see here, they raised a petition alleging that the patent claims were invalid over the prior art. And as you can see in the prior art figure that's shown in the drawing, it's quite similar, the concept, as what's being shown in the patent figure. However, in this case, it's interesting, and I'm raising it because the petition was denied, and IPR was not instituted because the judges raised the issue sua sponte that the claims being challenged were invalid under 35 U.S.C. 112, as being indefinite. The claims included some means plus function language, means for igniting, shutting off, and reigniting the rocket engine. Although 112 is not a basis for challenging the validity of claims in an IPR, the petitioner noted in his petition that the claims were directed to means plus function language, but there was no corresponding structure in the specification, and thus under the broadest reasonable interpretation standard, the claim should be broadly interpreted to cover any means. Based on that, the administrative patent judges felt that for sure the claims were invalid under 112 paragraph 6 and could not be interpreted because they were indefinite, and therefore denied the petition and shut this one down early. In comparison, in past cases, the judges have allowed some cases to go all the way through oral hearing before deciding the issue that claims were invalid under 112 paragraph 6 and terminating the proceeding on that basis. So in another recent decision, Riverbed Technology versus the patent owner Silver Peak Systems. This patent involves some technology involving the management of data storage across wide area networks. In this decision, it's quite significant because it is the first case where the PTAB has accepted some amendments that were proposed by the patent owner where those amendments were challenged. I think there was past cases where both parties had agreed and to allow an unopposed motion for claim amendments, but in this case, the claim amendments were challenged quite vigorously. I think one of the reasons that the patent owner was partly successful for the getting some of the amendments allowed was because of the quite significant narrowing of the claims that were made. The claims almost tripled in length and added some very complex processing involving very technical language, involving hash values, sync points, memory comparisons, and other limitations. Also, the patent owner included a lot of support for the patentability of these claims. In IPR, for filing a motion to amend, the patent owner has a very high standard to meet. They have to prove in the first instance with their motion to amend why these claims should be substituted and why the claims are patentable, covering all the statutory requirements for patentability. So that's their initial burden. And they met this burden in part with regard to some claims. First of all, they had made a showing that their substitute claims did not enlarge the scope of the original claims in any regard, that the claims are also well supported by the specification in general. Some of the claims, I think they did a good job, sufficient showing that they were patentable over the prior art. However, some claims are not allowed. In addition to showing that they're patentable over the prior art, you have to show that some claims, each claim is patently distinct from other claims. So the PTAB judges denied some of the claims because they felt they did not provide any patentable distinction over the independent claims they were depending from. In addition, the judges felt that some of the claims directed to software product claims, the patent owner did not provide a sufficient showing how those were patentable and eligible under 35 U.S.C. Section 101. In addition, some of the claims were directed to means plus function language, and the patent owner did not provide a sufficient showing that there was corresponding structure in the specification for each of the means for clauses. Still, nonetheless, they were able to successful in getting some claims allowed, which I think is a good indication for other parties to proceed and how to follow that course of action. So in the last case I want to talk about, again, it's a case where it was decided early on at the petition stage where the PTAB denied a petition, and it was more based on procedural grounds. Here, in this case involving a patent on a pharmaceutical composition, the patent had been granted during an ex parte prosecution based on a showing of unexpected results. The petitioner challenged the claims relying on similar prior art as came up during the patent prosecution originally, but they did not address the unexpected results, evidence that was shown in the prosecution history. And the PTAB essentially said it was unfair for the petitioner to ignore the evidence of unexpected results in filing their petition, because from a procedural point of view, it would put the burden on the patent owner to go first in explaining the patentability of their claims and relying on the same unexpected result evidence that was already of record in the prosecution history. And as a matter of fairness, the PTAB judges felt the burden is on the patent petitioner challenging the claims to address all these issues up front first. So with that concludes my section of the presentation. Please write down the password BRINCS, which you will need to, for some of you in certain jurisdictions, to include on your form to obtain CLE credit for this segment of our presentation. Now let me pass control of the presentation to Jim Cleland, who is going to continue our presentation discussing multiple IPR petitions.
Thanks, Mark. Just as a brief introduction, I'm a shareholder in the Ann Arbor office of Brinks, Gilson, Leone, and I practiced before the PTAB and post-grant review proceedings. What you saw with Mark's slides was that there is clearly an increase in the number of petitions for inter partes review filed with the PTAB in the last year or two. And what we're starting to see are other attendant trends developing. One of those trends is the board's use of 35 U.S.C. Section 325D to deny more and more petitions for IPR, particularly in the multiple petition scenario. First, let's look at the statute. The relevant portion of it is reproduced in this slide, and it addresses multiple proceedings. The statute reads, in determining whether to institute, the director, and that's the director of the patent office, may take into account whether and use it as a basis for rejection because you've submitted same or substantially the same prior art or arguments that were previously presented to the office. Now, as we'll see as we walk through this section, may has become more like should or must when the PTAB actually interprets this statute. The next slide shows the first part of a proceeding, just to provide a timeline for when you see these Section 325D challenges. On the left is the initial filing date of a petition for IPR. On the right is an institution decision. Statutorily, the time frame between those two events can be no more than 6 months. The patent owner has an opportunity to file a preliminary response. And as we've seen, sometimes patent owners choose to take advantage of that. Sometimes they don't for other strategic reasons. But when you're dealing with multiple petitions or second petitions, this is the time at that preliminary response stage that the patent owner should be raising that 325D challenge. There are also scenarios where a patent owner does not raise the challenge or simply chooses not to file a preliminary response, and the board, sua sponte, raises 325D in its institution decision. It seems like those are becoming more prevalent as time moves forward. I think the best way to understand how the board is using 325D is to look at some specific examples. The board has created three categories of opinions. The first category is precedential, the second category is informative, and the third category is routine. For precedential opinions, there's quite a process that's involved with getting an opinion designated as precedential, including being reviewed by the entire board, a special committee that addresses these types of decisions, and then ultimately approval by the director of the patent office. These are for novel questions, and they are binding. There really are not any 325 decisions that have fallen into that category yet. The next category are informative decisions, and these decisions are supposed to provide guidance on the board's rules and practices, or provide a representative sample of an opinion type. These are permitted to be cited as authority, although according to PTAB procedure, it's supposed to be non-binding authority. The last category is routine, which is essentially everything else. What I want to focus on here is the informative PTAB opinions, because these have been actually designated in that informative category by the PTAB itself. The first one is the ZTE versus Content Guard case. And I'm going to go over these opinions in date order. This is the first one that really addressed 325D back in September of 2013, back before it really became a larger blip on the radar screen. In this particular instance, there was a first petition filed that was partially denied, and then a second petition was filed on the claims that were denied in the first petition. The board was pretty firm in its view on that second petition. In denying that petition, the board indicated that a decision on a first petition should not act as a, quote, how-to guide for an unsuccessful petitioner, and that a patent owner should not be forced to defend the same claims from serial attacks. Now, it didn't necessarily help in this particular instance that the petitioner had also filed a motion for joinder, pointing out similarities to the existing petition in an attempt to try to get it joined. That was used against the petitioner. In the next case, shown down, Intelligent Biosystems, was similar, but you could argue that the board even took it to another level. Here, there was a first petition instituted, and then a second petition was filed, but it was based upon different prior art. In this particular instance, the petitioner, or the PTAB, faulted the petitioner for failing to explain how that new prior art was different from the art previously submitted. Now, this is where you start seeing the red flag for petitioner. And I think people could argue about this, but clearly this particular panel seems to have held petitioner to a bit of a higher standard, that not only do you have to come in with new art, but you have to explain how that's different from what was done before. The next three decisions here really go to different uses of 325D and how the board has used it to reject petitions in different ways. In this first case, Medtronic versus Robert Bosch Healthcare, now we're getting into the 2014 time frame. The petition was partially denied after the petitioner became an RPI which is a real party in interest, through an acquisition of a party that was involved in a previously instituted proceeding. Didn't matter that it happened, after that proceeding was already instituted. The board took a pretty firm line. In the second case, down, Prism Pharma versus Chunghwa Pharma, and this was a little bit different. There, the board used 325 to deny a petition because the prior art was presented to the patent office during prosecution of the patent, not in a previous IPR. So this opened up even more eyes, because not only did you have to worry about what you said in a previous petition, but now you have to start worrying about the art that was presented to the Patent Office during prosecution. And then the third case down, Unified Patents versus Personal Web Technologies, the board used 325D to deny a petition in light of a third-party IPR that was previously filed and instituted on the same patent that relied on the same prior art. So you've got to look at not only what you've done before, not only what's been gone down in the file history, but you also have to look at other third-party IPRs on the same patent if you're considering filing an IPR, and assess whether you've got a different enough challenge that 325D is not going to be a significant issue. Sometimes petitioners file a motion for joinder. That can work at times. In this particular instance, in the unified patent case, it did not. The board also denied a motion for joinder, leaving that particular petition kind of away from the table in that instituted IPR. And then the last decision that I think is worth discussing, that's been designated as informative by the PTAB, is the Konopko versus Procter & Gamble decision. I include this one because I think it really reflects the current temperature of the board. In this one, a second request was denied, and then the petitioner asked for a rehearing in front of an expanded panel. The board came out with some very strong language, which appears as a quote in the slide. And I'm going to highlight a couple of portions of that. The board said that approach would allow petitioners to unveil strategically their best prior art and arguments in serial petitions. I think that's a key phrase. Using our decisions on this institution as a roadmap until a ground is advanced that results in review of practice that would tax board resources, I think another key part, and force patent owners to defend multiple attacks. I think, and this is a late 2014 decision. This appears to be tipping the board's hand that it clearly disfavors serial petitions on the same claims involving for the same patent. I also think it raises some interesting questions going forward. Is taxing the board resources a legitimate reason to deny an IPR petition, particularly when the filing fee for each IPR remains the same? Is it wrong to force patent owners to defend multiple attacks if a patent is truly invalid? Again, I think these are questions that we all will wrestle with as we go forward, and may at some point get some play in the Federal Circuit or at a higher level of review. So we'll close with a couple of takeaway slides. The first one is as a petitioner, as a patent owner, it's important to know signs that Section 325D may be an issue. There's 6 of them here, and I think they all are worth considering if you find yourself in that type of a scenario. Number one, if you're filing multiple petitions on the same claims of the same patent using the same prior art, that's a dead giveaway. Number two, if you're filing a serial petition for non-instituted claims. Again, that's in the direct. You see that language taken from the opinions we looked at, and serial petitions are a red flag. Number three, there are other IPR proceedings by third parties on the same patents. This scenario, of course, happens many times, particularly with lawsuits by non-practicing entities against multiple defendants on the same patent. Those defendants don't always join defense groups and sometimes file multiple petitions. Number 4, a situation where a petitioner acquires a company and becomes a real party in interest on an IPR for the same patents that's already been instituted. We saw that instance in the law on the last slide. It's also important to note in number 5 that joinder motions can really provide fodder for 325D challenges, as we saw in the ZTE case. The same arguments you're making for joinder, which are similarities between your case and a case that's already instituted, can be used against you in a 325D scenario. You're really between a rock and a hard place. And then number 6. If you take a look at the cases in which 325D has been applied to deny a petition, you see a pattern of similarity amongst some of the judges. You see some common threads who like to use 325D more liberally. Some examples are Judge Laura Green, Judge Michael Zetcher are 2 examples of judges who seem to like 325D. I think it's worth taking a look at the judge. If you're in this scenario. And then finally, while 325D issues will always arise, it's sometimes impossible to avoid them. Here are 6 practice tips to try to avoid 325D. Number 1, always anticipate when you've got a multiple petitions on the same claim of patents, you've got to explain to the board why that combination is different. You have to explain why there's no redundancy. And you have to do that up front in the petition, because if you may never get a chance to again before the institution decision. Number 2, it's important, if you can, to use different prior art or combinations if you have to file serial petitions. It's tough to avoid 325D when you're relying on the same art. Number 3, the board has at times held petitioners to not only did you know about this prior art, was it in the first petition, but was the art known to you even if you didn't put it into the first petition. So to the extent that it's possible, try to use new prior art that's not previously known to the petitioner. Number 4, when describing new prior art in a second petition or a serial petition, the board has disfavored instances where a petitioner will simply cut and paste language applying a certain reference to the patent, and then cut and paste that language and do the same thing in the second petition, even if it's new art. Don't copy and paste. Describe the new art differently. Number 5, I know joinder motions can cut both ways, but it's important to at least consider a joinder motion when you're in a scenario where there's a third party who has already filed or has a petition that's been instituted on the same patent. It may be your only chance to enter that proceeding and at least have some ability to control the outcome on that patent. And then finally, in 6, submitting claim constructions in the petition. Different petitioners have different views on whether to submit claim constructions initially as part of their petitions, because they can potentially limit the scope of the claims. But if the board adopts a different construction than that submitted by the petitioner, or if it just goes off on its own and construes the claims differently, that may provide an opportunity for the petitioner to introduce new art to address the new claim constructions, thus taking away some of the bite of the serial nature of a second petition. With that, I'll provide the CLE password for this section of the presentation. It is patent with a capital P, and I will pass the baton to Nick Ristari. Thank you.
All right, thank you, Jim. As Jim and Mark mentioned, my name is Nick Ristari. I'm an associate here in Brinks, Gilson, Leone, Chicago office, and I'm going to be discussing actually more recent Federal Circuit decisions and the treatment of the first Patent Trial and Appeal Board proceedings on appeal. At this stage, there's been one appeal from a final written decision that's been decided by the Federal Circuit, but there have been several other proceedings that have made their way through to the Federal Circuit, and we've seen decisions in those. So I'm going to focus primarily on the procedural aspects of those proceedings and what they challenged at the PTAB and how that worked its way up to the Federal Circuit. So moving to the next slide, you saw this slide in connection with Mark's presentation, and Mark highlighted that there's been more recently a steady filing rate of about 150 petitions per month. I wanted to focus back on these proceedings went back into effect on September of 2012, and if you look at around that time frame, we're somewhere closer in the 40 petitions per month range. We saw an increase in June of 2013, and then sort of the increase to the current level around the April 2014 time frame. So if we look at the final dispositions that have come out from those early proceedings, you'll notice in 2013, looking at this right-hand column of this figure, 2013, there was 0 IPR final written decisions. 2014, we had 130. 2015, 141 as of March of 2015. So you can see that in the early months of the year, we already had as many final written decisions coming out of the PTAB as we did all of last year. So what does this mean in terms of the Federal Circuit? Well, I've heard it described as a tsunami of appeals are going to be working their way through to the Federal Circuit coming. So we may see different treatment of the later appeals. I think the first few that are going through are going to contain numerous challenges to different aspects of the program. The Federal Circuit will probably be deciding those ones and issuing opinions, but at some point we may start to see Rule 36 summary affirmances or that sort of treatment as the Federal Circuit grapples with how to handle this large influx of caseload. So looking at the early decisions that have come out of the IPRs and CBMs, there are several that I'm going to go through briefly. The main one I want to get to is the In re Cuozzo decision, but I want to talk about some of these other ones very quickly just to kind of highlight how we got to where we are at and to explain what those early challenges involve. So one of the first decisions that we saw come out of a PTAB case was the St. Jude case. It involved a situation where St. Jude and Volcano were in litigation in district court. St. Jude filed a complaint where Volcano counterclaimed its own patent. 2 years passed and the suit was eventually dismissed. St. Jude went to seek an IPR in that case, and the PTAB essentially denied it, given the statutory bar on filing a complaint 1 year after being served, or filing an IPR 1 year after being served a complaint alleging infringement. So in other words, the counterclaim suit filed by Volcano counted as a complaint alleging infringement. So this worked its way up as an appeal of an institution decision to the Federal Circuit, and the Federal Circuit, looking at that, said, we do not have authority to hear this appeal, given that Section 314D contains an explicit bar on the appeal from institution decisions. Therefore, this is one of those scenarios where the Federal Circuit cannot hear appeal of this issue. But it left open a question, so not to be deterred. Other cases came about where, well, if we can't appeal the decision, what about trying to seek a writ of mandamus, setting aside the board's institution decision for one reason or the other? And just for time constraints, I'm not going to go through these decisions in detail, but there are several decisions that essentially sought review of a decision to institute or a decision not to institute based on where the party attempted to seek a writ of mandamus, setting aside the institution decision for one reason or another. They usually involve procedural issues such as whether or not the complaint was barred by the service of a prior complaint, or whether or not the IPR was barred because the petitioner had filed a prior civil action challenging validity of the patent. So in these three decisions, the first two, the Federal Circuit refused to use a writ of mandamus to set aside a decision to institute. Then in re Dominion Dealer, the Federal Circuit declined to issue a writ of mandamus in a situation where we had a decision not to institute. So if we look at the requirements for a writ of mandamus, they're actually quite high. You need a clear and legal right to relief, no adequate alternative legal channels, and that it's appropriate under the circumstances. So in those scenarios, they looked at the facts, they looked at the legislative history behind the bar on an appeal of an institution decision, and basically came to the conclusion that there was no irremediable harm justifying the writ of mandamus. So it wasn't, they weren't going to entertain a writ of mandamus at the institution stage. Now, interestingly, they left open the question of whether or not they could revisit the institution decision after final written decision. So the statute bars review of an institution decision, but perhaps once the board issues a final written decision, in which the final written decision may be appealed, whether the board can now go look back at the errors in the institution decision that way. So essentially through the lens of the final written decision, if you will. So the first case, as I mentioned, to make its way to the Federal Circuit after final written decision is in re Quazo. So now that involved an interesting scenario where at institution stage, the board instituted on two claims, claims 10 and 14, on grounds that were not identified in the petition. So on appeal, Quazo, of course, argued that that was error, that the board should not have identified its own grounds outside of the petition, was limited to those grounds. And now the ultimate unpatentability determination that came through in that case was based on those same grounds. So the same error present in the final written decision, but it really the main error came at the institution stage. So it was essentially a challenge of the institution decision through the final written decision. So when the Federal Circuit heard that case, they essentially had two holdings. They said, or with this respect, they said Section 314D, the no appeal statute, explicitly provides that there is no appeal of a decision to institute. Therefore, they cannot review that the supposed error that came at the institution stage, even after the final written decision. So they kind of foreclosed that last door that had opened of whether the final written decision, you could reach the issues of the institution decision that way. But they said there was a strong dissent. Dyke and Clevenger, writing from the majority, said, well, there's the aggrieved party is not without remedy. They may seek a mandamus may be available to challenge the PTO's decision. So again, leaves open this idea of a mandamus may be available after a final written decision, although we saw it failed in the prior instances at the institution stage. So having said that mandamus was a possibility, they sort of went on in dicta and construed the appeal as a request for a writ mandamus, and they said in this instance, under the facts of Quazo, they said there was nothing in the IPR statute that expressly limits the board's authority at the final stage to the grounds alleged in the IPR petition. So in other words, there wasn't a clear a clear set of facts showing that there was that met the requirements for mandamus, that there was a clear legal error with no other remedy, and the board essentially, or the panel, said that mandamus was not appropriate in this scenario. Interestingly, they analogized to a reexamination case where the final decision of the board washed clean all the original error during the institution decision. And just by way of background, this is when the statute precluded re-exams on art that was before the examiner. So at the institution of re-exam in that case, the office was relying on art previously before the examiner, but during the final decision, the examiner had switched the rejection to art that was proper. So the final decision washed clean. I'm not quite sure how that applies to the facts in Quazo, since the same error at institution decision would have been presumably at issue in the final written decision. But the panel sort of dismissed that subtle difference by saying it is not clear that the IPR is strictly limited to the grounds asserted in the petitions. So in other words, looking at this issue, it's not clear that mandamus is appropriate. So the board, has, at least under these facts, has rejected that as a possibility, still leaving open, of course, that it's a possibility in a situation down the road. So Inouye Quozo also had another holding, that a procedural challenge to the PTAB proceedings that's worth discussing. Quozo had argued that the broadest reasonable interpretation was not appropriate for PTAB proceedings, mainly by anybody who follows the proceedings. As Mark mentioned, the ability to amend has been almost non-existent. Mark discussed one of the few cases where we saw that an amendment was successful. There were a few others, but they were essentially stipulated to amendments. But the vast majority of motions to amend have been denied, and it's a very high bar. So Quozo challenged that the reasoning for broadest reasonable interpretation, which would be the ability to amend your patent, wasn't available in PTAB proceedings, and therefore it wasn't the correct standard. The Federal Circuit looked at this issue and said, well, Congress, in passing the AIA, was legislating against a 100-year backdrop of patent office proceedings that applied the broadest reasonable interpretation standard. So they certainly knew that the patent office was applying the standard. They didn't reach the issue specifically, but the patent office was applying the broadest reasonable interpretation in every PTO proceeding involving unexpired patents. So certainly they didn't seem to be conflicting with the AIA at all. But even if Congress did not adopt the broadest reasonable interpretation standard, Section 316 did delegate to the Patent Office the authority to promulgate rules for these proceedings. And under that authority that had been delegated to it by Congress, it acted reasonable in adopting the broadest reasonable interpretation. Some of the reasoning was interesting. The panel said that the motion to amend was cabined, but not non-existent. So there were high thresholds that had to have been met, but essentially the ability was there. So that was part of the reasoning for applying it. They did, in addressing the claim construction issue, they did apply the recent Supreme Court's holding in Teva, which I just wanted to mention sort of in passing, since it's more of a merits issue. But they said that they would review the PTAB's construction de novo because there were no underlying issues involving extrinsic evidence. So if you recall, Teva said the standard for review for claim constructions is de novo unless there's issues of extrinsic evidence that have been decided by the underlying court or board, in which case those are reviewed for either clear or presumably substantial evidence in terms of the board. So in this case, there was expert testimony going to the relevant claim construction, but for whatever reason, the court did not see a underlying issue involving extrinsic evidence on that basis. So as I mentioned, Dyke and Clevenger wrote the majority opinion. Newman filed a fairly strong and heartfelt dissent. She argued that several of the panel majority rulings are contrary to legislative purpose. In particular, the two that we just discussed said the institution decision should be reviewable as part of an appeal of the final written decision. In other words, the focus of Congress in precluding review of the institution decision was simply to keep proceedings on track for 1 year, and to prevent interlocutory appeals. It shouldn't preclude review after the final written decision. Claim constructions, they argued that it should be given the correct construction, which would be the Phillips, I presume, and not broadest reasonable interpretation, basically because the motion to amend is illusory, or at the very least, it's distinguishable from the ability to amend your patent in other proceedings, namely ex parte, old reexaminations, as well as prosecutions. So it's a very different situation. And just briefly here, I want to just discuss a couple of the appeals that are in the pipeline and what we might see in terms of procedural issues that are being briefed and decided. The Versada case is fully briefed and awaiting a decision, and they've challenged whether patent qualifies as a covered business method, which of course is determined at the institution stage. So we'll see how that plays out. and also estoppel and claim preclusion. And then the retirement capital case is making its way along, and that's whether 101 is a proper ground for covered business method reviews. So we'll see some other potential procedural challenges that I've just sort of listed out there. I think the Federal Circuit will continue to evaluate these at least first few appeals from the PTAB proceedings until some of these procedural challenges are worked out. Once those are settled, perhaps we'll start to see the Rule 36 decisions. Okay, and with that, I'll give you the final password for CLE will be PTAB. I think I will pass control back over to open it up for any questions.
So if you have questions, please type them into the Q&A section section of the panel on your screen, and we'll address them. We do have one question that's come in, and perhaps, Jim, you can handle this question. The question is, has the lowering of institution rate of petitions for IPRs had any impact on the rates for granting motions to stay in district courts?
Yeah, that's a great question. I don't know of any direct statistics, but anecdotally what we're seeing is that whereas many courts used to rely on the mere institution rates and IPRs as a basis to grant a stay. In other words, before a petition was even instituted, the stay would be granted. Now a lot of courts are saying, you know what, we're not going to give you that stay just because you filed a petition. We're going to wait until the institution decision to give that full consideration, because only with institution do we know that there's going to be an estoppel that would give us the quid pro quo, which is we don't have to handle some of the invalidity issues that are being handled in front of the patent office. So courts are changing their tide a bit on how they handle these stay motions.
Okay. All right, thanks, Jim. We have another question here relating to the Federal Circuit, so perhaps Nick can handle this question. Now, the question is, as we have seen, there are not many options for appealing an institution decision to the Federal Circuit. What options for rehearing and reconsideration of a particular panel's institution decision are available, and what are the chances for success? And are there options for review by an expanded panel? Nick?
Okay. Yeah, thanks, Mark. So I think the question, taking sort of the first subset of that, is what options for rehearing, I believe, are available. In my practice, and I've been involved at least directly or indirectly in probably over a dozen or so of these proceedings, and through the institution stage, once the panel has issued a decision on institution, I think early on, and maybe even continuing today, we saw a lot of requests for rehearing to reconsider that some part of that institution decision. And I think you generally have a very uphill battle with a request for rehearing or reconsideration of the institution decision, just because you are asking the board to essentially reconsider its own ruling it just made and somehow decide that it is now wrong. So I think where we see more success in the request for rehearing or reconsideration is when the panel has truly overlooked something, where you can identify in the record where there's something that the panel has overlooked or misapprehended, and it's a legitimate request to reconsider that evidence and that it has a dispositive outcome on some issue that they ruled on. I think you'll see a lot more success. For some of these other procedural issues that I talked about getting up to the Federal Circuit level, I haven't seen much success in terms of those, just because they're more factual-based questions with respect to maybe what's happening in the corresponding litigation. I think you're going to be a little bit more hard-pressed to point to facts that the board did not previously consider or overlooked for those type of decisions.
Thanks, Nick. There's another question has come in that I probably is open for any of us to answer. So I'll start with an answer, and then if Jim or Nick have any added input. The question is, what impact do you believe the use of a PTAB proceeding by a hedge fund to kill patents will have on the PTAB's overall attitude and decisions? Well, I don't believe that there is going to be, at this point, any change in the attitude of the PTAB from what I've seen. This is a relatively new use of PTAB by hedge funds to influence shareholder perspective on the value of corporations based on the value of the patent portfolios of these companies. But it's not very prevalent. So I think that PTAB is dealing with a lot of different political influences, and I think the stronger influences still remain the public eye crowd against the abuse of the patent system by non-practicing entities. I believe that there's been some discussion in the legislative effort in amending the AIA to address some of these hedge fund misuse of PTAB proceedings. But overall, I don't see a significant change in how the PTAB addresses any petitions coming in from a hedge fund.
Yeah, and I'll just add to that. I think Mark made a good point. He said this is more of a recent practice, so there hasn't been sort of any type of informative decision or type of consistent ruling that we've seen a trend on this type of thing. I mean, really what the PTAB here, at least in terms of IPRs, they're evaluating just whether there's a reasonable likelihood of success and based on the evidence and petition. If a patent isn't valid and a petition sets forth the evidence to demonstrate reasonable likelihood of success on that, I don't think it should change the calculus as much based on who the petitioner is. Of course, with covered business method reviews, on the other hand, you do have a little bit more stringent standing requirements. So I don't suspect that many of the hedge funds would meet the standing requirements for filing those proceedings.
Yeah, Jim, your thoughts?
All right.
All right. Well, I think we have just time for one more question that's come in. The question is, attempts to amend claims are rarely granted. In the Riverbed Technology case, in which the PTAB granted the patent owner's motion to amend the claims, what level of detail did the patent owner use to distinguish the prior art to carry its heavy burden to show that the claims are patentable? Well, I can address that question. And let me say that, first of all, a motion to amend claims is very limited in terms of the number of pages that are available. I think it's 15 pages, and if you have to address all the grounds of statutory grounds and requirements for patentability, that does not give you a lot of space to do so. And I think in the Riverbed case, if you take a look at the decision and the particular claims that were presented for substitution, they are very lengthy and very detailed and very technical. And I think the claims do speak for themselves, but there were some detailed arguments presented showing limitation by limitation how each limitation was different from the prior art. So what's even more interesting is that the patent owner met its burden to show the patentability of these claims without the use of a technical expert. And the PTAB noted the lack of a technical expert, but said, hey, technical experts are not needed in every case. They're not needed when you file a petition, and they're not needed when you file a motion to amend. And if the nature of the amendments you're presenting are such that it's clear from your explanation that they're patentably distinct, that will be enough to carry your burden of persuasion. So with that, I don't know, Nick or Jim, if you have any other input on that. If not,
right.
Yeah, if not, we'd like to conclude our presentation today, and I want to thank everybody for dialing in and joining us. If you have any questions that you think of later, feel free to send an email to Mark, Jim, or Nick, and we'd be happy to get back to you. If you have any suggestions for other topics that you'd like our firm to present in a future webinar, or if you have comments and suggestions for improvement, we'd be happy to hear from you. Please send an email to any of us. So with that, thank you very much for your attention today. All right, bye-bye.